Welcome to Off the Clock, the webcast of employment attorneys at Miller Johnson, where we discuss what is happening in the HR world and provide practical insight and advice. We are your co-hosts, Rebecca Strauss and Sarah Willey, two employment lawyers who spend their days guiding employers through all of the challenges that workplaces offer.
Hello, welcome to Off the Clock. I'm here with my partner, Sarah Willey. I am Rebecca Strauss. Today, we are cleaning out our COVID closets. We're going to help explain what's still in, what you can get rid of, and what the current guidelines are. Good morning, Sarah.
Good morning, Rebecca. How are you?
I'm awesome. How are you?
I am very well, and I am excited, actually, about our conversation today.
Really?
Yes.
Excited about COVID?
Excited about COVID because, I'll say this. This past week, 2 weeks, I've been getting so many clients reaching out, emailing and calling to ask this question. What do we still need to be doing as it relates to COVID?
Right. Yep, me too.
And I think it's a really important question. Many employers certainly want to be safety conscious, right? They want to follow the rules, etc. But they'd also like to get rid of the plexiglass if they don't need it anymore, right? The directional arrows,
Right.
COVID pay, etc. So we're going to dive into that question today. What should be in and what should be out?
Right, exactly. So let's start with the topic that took over our lives and our clients' lives last year, vaccines. For
Yes,
clients that never
excellent.
had a vaccine mandate, this might not be top of mind. But for clients that did and may still have a mandate, they might be wondering, well, what happens now? Right, with
Yes.
applicants that apply and are not vaccinated, are they still going
Sure.
to enforce it or not? So let's first just go through the checklist of the laws, the federal laws that required some employers
Great idea.
to
Yeah.
have mandates. And then we'll
Yes.
talk about all the other employers that did it, maybe not because they were mandated to, but for other reasons.
Okay,
right?
that sounds great.
Okay. So should we start with OSHA? That was the big one, right?
Yes, and that was the one that applied to all businesses with more than 100 employees. Is that right?
Yes.
Do I remember that correctly? It's funny how I block these things out, right?
I
as with much of our audience.
I think
probably.
we both have.
Yes,
So
exactly.
there was a whole bunch of hoopla, and then the Supreme Court said not enforceable, and then OSHA withdrew the temporary standard, but said it was still going to consider it as a final
Oh,
rule.
that's right.
So
and we
if
were
you're-
waiting to see, weren't we?
We were, and they haven't done anything. And they even
Okay.
said at the time it wouldn't be a priority. While they were still going to consider it as a proposed final rule, it would not be their priority. And in fact, believe it or not, the government did what they said and did not make it a priority. Haven't heard anything about it. And given the trajectory of where we are and where the federal government is on vaccines, I doubt we're going to see that rule be finalized.
Okay.
So I don't think we need to worry about the OSHA rule.
Okay.
Let's talk about our healthcare.
Right, I was going to say
employers for a
there's
moment.
two other, right, healthcare and federal contractors. So let's start
Yes.
with the healthcare. What about them? There was a CMS rule, wasn't there, that applied to healthcare organizations?
Yes, the same day the Supreme Court said that the OSHA rule could not be enforced. It said that the CMS rule could,
Right.
and it is still in effect. And in fact, just a few months ago, about 100 hospitals or so were cited for not complying with
Okay.
the CMS mandate. So there's nothing really new there, but it's still in
That is
effect.
still, that's staying in the closet, right?
Yes, that is
so, right. So,
Yes.
and just a reminder that CMS rule didn't apply to every single healthcare employer. It was a narrow category of healthcare businesses. And remind me of the verbiage, Rebecca, that was...
If I can remember, because I haven't wanted to think about it lately either, but basically Medicare participants.
That's right.
So
That's right.
not the patient, but the organization itself.
Right.
So for an organization to participate with Medicare, it's very intentional. And
Yes.
frankly, a lot of hoops to jump through. As I said at the time, when I would talk to clients, this is not the sort of thing you can accidentally be.
You know if you've signed an agreement
Right.
with Medicare and Medicaid to be a participant.
Correct.
And so if you were one of the organizations back then that
Yeah.
had the CMS rule apply to you, it still is in play, still does apply. And importantly to me is that CMS is actually citing healthcare employers for not complying with it.
Yeah, CMS said they're working with employers first. Their goal
Okay.
is not to be punitive,
But they're enforcing
to
it.
encourage compliance, to encourage more mandate. But yes, there is enforcement taking place. So if you are covered by the CMS rule, in some, carry on, right?
Right.
That's still in, carry on, do what you were doing.
I see. Okay.
For the past year.
And then federal contractors, boy, has this been a really gray area, in my opinion. We've had lots of decisions from lots of different federal judges saying it's enforceable, it's not enforceable, some applying to only some states, some applying to all states, et cetera. Where are we with that thing?
It is like a law school case study, right? Like
Yes.
law students will be studying this. What happens when there's a lawsuit in one state? Who does the judge's decision apply to? Who doesn't?
Right.
It's been a roller coaster, as you said. Recently, the federal judge that issued the national stay.
Okay, meaning
so-
not enforceable. A
Right.
stay means
A stay
that
of the
mandate is
rule.
yeah, okay.
Yep. So months and months and months ago,
Okay.
a federal judge said the federal contractor mandate cannot be enforced anywhere in this country.
Anywhere against any employer. Okay.
The judge recently said, I'm going to narrow that a bit.
Oh,
it
no.
actually is going to be enforceable in part of the country. The federal government's response is we are not going to enforce
Oh,
that provision in federal contracts. So the government did not say this directly, but my interpretation is the government said, don't worry about it anymore, right? It's out there, but if you are a contractor, a subcontractor, et cetera, you just don't need to worry about it.
Okay. Now, I know of several federal contractors or subcontractors that complied with that mandate. Does that mean they shouldn't have a vaccine mandate then, Rebecca? What does that mean for them?
I think it means they can, but they will not be required to,
Okay.
if that makes sense.
Okay. So as it said, because when I think of a vaccine mandate, of course I think about the ADA, right? Is an employer allowed to require employees to receive a vaccine? Okay. And so the EEOC's position has not changed on that. In other words, they continue to say any employer can require the COVID vaccine if they choose. Of course, we also know they have to make exceptions for two reasons, which is if an employee has a disability or a sincerely held religious belief and can't receive the vaccine for one of those two reasons, right?
I think that federal contractors are now in the same bucket as employers
That's
who
a
are
good
not
way to think of it.
required to but chose to.
Yeah.
So now federal contractors are in that same category, and I completely agree with you. I think that the law of the land is still, yes, you
Okay.
can, but we do need to consider those accommodation requests for disability and religion. So let's talk about that. Back in the day, we did a whole episode on that.
We did,
One
yes.
of our most popular episodes.
I know, right? I don't know what to make of that, but yes, true.
Everyone needed to know at the exact same time,
Right.
particularly with the religious accommodations, but also the ADA accommodations. And just to take a step back a moment, because this is going to come in again later in our conversation, there's always been something about COVID where people not forgot, but thought it was a special type of situation to where the regular ADA or Title VII accommodation process didn't apply, right? We know these processes. We've been in
Right.
HR a long time. We're good at what we do. But when it's COVID related, right? Like this must be different. And in fact, it's really not, right? And that's what we reminded people of
Yes,
back in the day.
yes.
So let's go through a quick analysis now of an employer who is choosing to have a vaccine mandate.
Okay.
And they get a request for an
It's like a
accommodation.
pop quiz. Yes.
It is like a pop quiz. And they get a request for an accommodation. We talked before about how you evaluate that, right? Is it a reasonable request? Does it cause an undue hardship? I don't want to go through that whole episode again, but Sarah, what do you think has changed since when we talked about that almost a year ago?
Right.
To now,
Right.
when
Right.
employers go through that process.
Right. So let's take, for example, let's presume somebody is unable to get vaccinated because of some sort of medical impairment, right? That would fall under the ADA. And let's just assume that, yes, they do have a disability under the ADA, right? Okay. To your point, we would handle that just like we would any other request for accommodation under the ADA, which is to say we would provide that accommodation unless it's an undue hardship, okay? Back in the day, back in 2020, 2021, even at the beginning of 2022, employers, I think, had a very, very good argument or stronger argument that there was a significant safety concern as supported by even our federal government, right? That allowing an unvaccinated employee to be in that workplace could create a risk of harm to that employee or others. I personally feel less comfortable making an assumption that that is still true. How do you feel about that?
I agree. I think the change in isolation and quarantine requirements, which we are going to get to, those make the argument harder too. Not impossible. It's going to be very fact specific, frankly. Right. It's going to be very fact specific, but I don't think employers can just jump to the conclusion that yes, of course, right? Of course we're going to win that argument, that we have a business necessity.
Exactly, yeah. I agree with that. And I think it's not only the changes from the CDC about quarantine and isolation, but the federal government saying they're not going to enforce the mandate against federal contractors anymore, right?
Yes. And they have stopped with their own. There is another mandate. There are actually two mandates that we haven't talked about because they don't apply to a lot of our listeners. But one is for federal employees themselves. And the government has stopped treating vaccinated employees differently than unvaccinated federal employees in terms of access to buildings, et cetera. So that gives us a clue as to where the federal government is on this. One last point on vaccines. Think about what it means to be vaccinated, right? So we have the initial dose, the second dose,
right?
Unless you're
yes, I know where you're going with this. Yes,
then you had the third booster. If you're over 50, the fourth booster. And now, fall of 2022, we have a new and improved booster to address the newest variant. So if you are going to have a vaccine mandate still, think about how you
what does that mean?
Being vaccinated.
Right, exactly. And can you really argue that an employee not receiving the old vaccine that may not be as effective now prohibits them from being in the workplace, right? And where is the relevance there?
And for folks that still do have a mandate and want to, are we going to require now folks to get the new booster?
Oh my gosh, I can hear just all of the HR folks across the country right now just groan when you say that at the thought of having to at the thought of having to require and track down that information again.
This may be why, maybe, just taking a stab at it, vaccine mandates are less popular now.
Yes.
Than they were
so
9 months ago, a year ago.
What's your feel on that? What's your read on that? How many non-healthcare employers are requiring the vaccine right now, do you think?
I never thought it was that great, and I think it's lower now. And one organization that studied it, that looks at the number of want ads that say that a vaccine is required, has noticed a drop. Okay. So I think we're seeing that drop off a bit.
That drop off a bit too. And I would agree with that. And I would say the businesses that I know made the decision to have a mandate in the first place are generally not requiring the booster or the new vaccine.
They were doing it mostly because of the federal contractor mandate, frankly, or the CMS.
And are now deciding what to do about new hires and whether to continue that.
Yes.
Okay.
All right.
Let's talk about another question that I'm getting quite a bit is, what do we still need to be doing when somebody has COVID?
Yes. That's the biggest, I think, because so many people have COVID or have been exposed in the last few months. It's just numbers are high.
Right. Do we still, and the questions are twofold. Number one, do we still need to be keeping them out of the workplace for a period of time? And number two, is there any requirement still to pay them for that? And actually, let me add a third one. Is it job protected? Is that time off job protected?
These are all hot questions right now. Let's start with just isolation and quarantine periods.
Okay.
And as a quick refresher, as if like other people like us, they haven't thought about this deeply in a while, isolation refers to when you have COVID. Quarantine refers to when you've been exposed. We'll try to remind people of what we're referring to as we go through the rules.
So isolation is I've tested positive. Quarantine is I've been exposed to somebody. I've had close contact with somebody who tested positive. Okay.
Yes. So let's do the easy one first.
The isolation, right? Yeah.
That's how I am. Okay. So let's talk about if you have COVID. So what is the latest CDC guidance on that?
Okay. So the latest CDC guidance, Rebecca, is that if you've tested positive for COVID, you are supposed to stay home and isolate for 5 days.
Okay. Don't go to work.
Don't go to work for 5 days, and you're not supposed to do other things either. But the most important, for the purposes of our listeners, is don't go to work.
Okay.
Now that 5-day period starts either when symptoms began, or if that person doesn't have any symptoms, then it would start from the date they took the test.
Took the test, not the result.
Yes, although I will say most people are taking the rapid test now, so there's less frequently is there that delay. But yes, so from when symptoms began, or if no symptoms, when they took the test. Okay. And the day, the first day is day 0, right? So if my symptoms started today, my 5 days would be Tuesday, Wednesday, Thursday, Friday, Saturday, and I would get out on Sunday.
Okay. Perfect. So just to be absolutely crystal clear, because this is the question these days, an employee calls their supervisor or HR and says, I tested positive for COVID. I woke up feeling sick this morning, took the at-home test, tested positive. How long do I stay home for? When can I come back to work? The answer is, at minimum, you stay home 5 days.
That's right.
Okay.
That's right. And our recommendation is that employers are following that CDC guidance on that.
Yeah. And then what happens after that 5-day period?
Good question. And this is something that I'm not sure everybody is as aware of. The CDC says that you can stop isolation after 5 days, but you're supposed to wear a mask until day 10.
Okay. We think folks are missing that.
Yes.
Yes, I agree.
I don't think I know that they're missing that, just in my general observation of the world. Not in a judgmental way. I just don't think that people are following that rule, but I do think it's important for our listeners to at least be aware of that.
I agree.
So then what about pay, Rebecca? Are employers required to pay employees if they're following that CDC guidance with regard to isolation?
I mean, the simple answer, which I never give, but I'll start with it, is no. The simple answer is no. There are no federal or at least Michigan state specific.
Yeah, I was going to say, be careful, be careful.
I told you it always gets more complicated with me, Sarah.
Every podcast, I have to remind everybody, right? Be careful of California and other states.
Have I ever really had a one-word answer to any question, be professional or personal? No. So it can be state specific, right? Look at your states. In Michigan, there's no requirement for paid leave. Under federal law, there's no requirement for paid leave. So let's talk about job protection then. What if someone's out of PTO or sick time or whatever your organization calls it, and now they're supposed to be home for 5 days? Can you fire them if they're out of time off? There used to be a hodgepodge of protections out there, right? The FFCRA in Michigan, Public Act 238, almost all states had
some sort of protection, statutory protection for that time off.
Still look to your state, but a lot of them have gone away. Certainly under federal law, there's no COVID-specific job protection for leave. In Michigan, there's nothing COVID-specific. California still has COVID-specific, and other states may as well.
And I'm going to go back and just emphasize one point you just made. You mentioned Michigan Public Act 238,
Our favorite Public Act
number. Because we've talked about that a lot, and we sort of burned it into our listeners' brains, and I feel like we need to really scrub it out now. That has been rescinded, right? So for all of our listeners, if you didn't know, Public Act 238 has been rescinded. That was the Michigan law that required job protection for employees that were quarantining or isolating or even had symptoms of COVID. That no longer exists.
Very important. Okay, so now there's nothing, at least for a lot of employers, again, check your states, but for a lot of employers, there's no COVID-specific leave.
I know where you're going with this.
It's your favorite.
It's my favorite.
Your two favorites. I don't know how you pick your favorite child. FMLA and ADA. Let's not forget about those. And
it's just like everything else now, right?
Back to a comment I made at the beginning of this. FMLA and ADA always applied to COVID. Always, always, always. But there was something about COVID that seemed special and different, right? So people didn't necessarily think ADA and FMLA when an employee had COVID. But now that's all that's left, frankly, for job protection. And you really do need to think about it, not just for those 5 days, but for long COVID too, right? For some individuals, it's not over after 5 days. Correct. So let's not forget our back to basics when it comes to FMLA.
It is still a medical illness, right? And so the FMLA and ADA apply to it.
It might be serious, triggering the FMLA, maybe. But if it's not, right, that ADA could still.
So let's talk about, we talked about isolation. What about quarantine? Are employees still required to stay home if they've been exposed to somebody who's tested, who has a known case of COVID?
Well, there's really been an evolution there.
Yeah.
And the answer is, okay, I'm going to give it to you in one word, but then it's going to get more complicated. The one word answer is no. No.
Right. Yeah.
But.
And let's pause there, because that means that we had a change with the way the CDC was viewing this, right?
Absolutely.
Okay, so they've now changed their guidance to say, regardless of whether you're vaccinated or not, you don't have to quarantine if you've had close contact with an individual with COVID.
Correct.
Right?
Let's pause there for a moment, just to circle back real quick to our vaccine discussion.
Okay.
That used to be one of the reasons being vaccinated, right, was a business necessity.
Sure.
Because the quarantine rules were different.
And
so by having your workforce all vaccinated, you have less absenteeism.
Yeah.
Right?
Less
That's
disruption on the
evaporated
business.
now. That's evaporated now.
Okay.
The rule is the
Excellent.
same whether you're vaccinated or not. So I don't want to brush by that too quickly.
So employers do not have to require employees to stay home. And by the way, I'll just say, I'm not even sure employers necessarily know anymore when an employee has had close contact with somebody with COVID. We're just living in a different world in different times, right? They're no longer calling HR necessarily and telling them these things. But if they do know about it, we don't have to require them to quarantine. And there is a but, though. The CDC does say we are supposed to do what?
Masks. Masks have not become irrelevant.
Right.
You would think they are in most workplaces and just walking around in the world. But the reality is the CDC still says to mask for 10 days after exposure.
Right. Yes. Okay.
And that's going to come as a surprise for a lot of our
listeners. It's going to come as a surprise.
Because I was waiting for the collective
yes.
gasp or deep sigh.
Yeah.
Perhaps.
They are
HR
still saying
folks,
that. Yeah.
Thinking about fighting the mask wars at work again.
Right.
And
so we'll just leave it there, and they can yell at the CDC about what that requirement is. That's right.
Right.
That's right. And the CDC also does recommend testing.
Yes.
But not until 5 days after the exposure.
Let's talk about testing in that context, but then in general too. Okay. And we won't spend a lot of time on it because you and I talked before the show. We just don't think there's a lot of testing going on anymore. But let's just talk about the employee who has symptoms. Can an employer require them to take a COVID test?
Yes, I believe so. I think the EEOC guidance, now again, that's a required medical exam, arguably, right?
Yeah.
But I think there would be, that's consistent with business necessity and consistent with the CDC guidance, right?
Now, the EEOC guidance on testing has evolved fairly recently. Routine testing used to be blessed, if you will, by the EEOC.
Right.
We're now getting back to where we were, I think, before COVID when we think about medical testing. And now the EEOC is saying test when there's a business necessity.
Yes.
So if you are folks that are testing everyone routinely as they come through the door, I don't think that's happening a whole lot, frankly, so we're not going to take a lot of time talking about it. But you are going to have to think long and hard about what the justification
whether to continue
is.
to do that. And one easy way to think about this is this. The EEOC uses that term consistent with business necessity, which of course it's very gray and nobody knows exactly what that means. But they do us a favor. They say that if the test is in line with what the CDC is recommending, they will always conclude that it's consistent with business necessity, right? So as an employer, if you're wondering whether or not you should require a test, my advice would be go look at what the CDC is recommending. And if the CDC is recommending you test in that circumstance, then yes, you can require it. If the CDC is not, then I think you need to take a time out and consider whether there is a different legitimate business necessity to do that.
Perfect. Yep. Okay.
What about everything else? We're cleaning out the closet, right?
What about everything else?
What about everything else?
Can we talk for a minute about the COVID preparedness plans?
Right. I've
Should
had
we
a lot
pause
of
as everyone
questions about
shudders?
this. Yes. Yeah. My questions that I'm getting are usually centered around, okay, if I still have to have this thing, it requires serious updating because it says we're doing things that we're just not doing anymore.
And by updating, we mean throwing out probably 80% of it.
Correct. Correct.
Like the plexiglass, like the arrows, like the staggered brake system, like the drinking fountains, like the notifying close contacts. Let's think about that. Identifying
the hand
a COVID
sanitizer.
safety supervisor.
Remember when they had to designate a person to be
Yes.
on site as the COVID safety person? Yes, there's all
was
of
me.
those things. Oh, you were, that's right. You were Miller Johnson.
It's not on my website as one of my qualifications. One of the greatest honors of my life. Yeah. So if you remember, we had those plans, frankly, because it's always good to have a policy and a plan for everything, but because the law required it, at least in the state of Michigan.
Yes.
Right? They were required.
There was an executive order that required it. Yes.
The good news is it's not required anymore. They're not required anymore to actually have a plan.
Right.
But let's think about the contents of the plans now. Mm-hmm. Is there anything that should be kept in or kept out? What do you think?
When I think about what should be in a plan and what an employer should be doing to protect the safety of employees from COVID specifically, I, number one, think about following what the CDC's recommendations are, right?
Yep.
And number two, looking at the workplace and identifying where there could be particular areas in which transmission of COVID is high, right? Is significantly higher than other places, and potentially making some adjustments specific to those places. I also think about making very, very, very clear to employees that they cannot come to work when they know they have COVID.
Right.
I think that is the most important thing.
Yeah, because employees, now that they don't have protected leaves, right, and may be out of all their sick time or PTO,
Right.
might be less likely,
Yes.
right, to tell an employer.
Yeah. So what still exists is the general duty to provide a workplace free of known hazards that could cause death or serious bodily injury.
Yep.
Right? And in this case, it's the virus.
Yep.
And so the only way an employer can take action to keep the virus out of the workplace, right, to satisfy that general duty is to do what it can to make sure employees who know they have COVID do not come to work and spread it to others.
I think two additional points on that. One, your old preparedness plans that were pages and pages and pages long still keep them as an archival document.
Oh yeah, you want to
right?
demonstrate that you had it.
When we say you might not need it anymore, or
Right.
in this case you can toss it, you can clean it out of your closet, save it somewhere to prove that you had it and were compliant.
And I would add to that, document the time period in which it was applicable.
Right, great idea. The only other thing I would add is, depending on the virus level in your particular community or perhaps your particular place of employment, you can have these things come and go. There may be a period where you distance everyone again, or you have everyone wear
Right.
masks again, right? If
Right.
it's spreading like wildfire through your organization. It doesn't have to be an all or nothing. But without all these requirements now of what you have to do, there's a lot more flexibility,
Sure.
right, to right size the response to what's happening in your particular
Okay.
place of employment.
So as we're cleaning out the closet, the plexiglass can go.
Yes.
The directional arrows can go. And by the way, I am speaking to non-healthcare clients.
Absolutely.
Healthcare clients have different requirements in place. Okay. So for non-healthcare clients, they can, they don't need to update their preparedness plan, but they should save it. They don't need the plexiglass. They don't need the hand sanitizer everywhere. They don't have to keep the directional arrows.
All the warning signs.
All the warning signs.
Those very welcoming warning signs you remember at the entrances to businesses.
Get out.
We
But
don't
they
want
should, but they should continue to make clear to their workforce that if an employee has tested positive for COVID, they are not to come to work. They need to follow the CDC guidance. They should make sure that leaders, supervisors understand the importance of that. And they should otherwise be following what those CDC recommendations are.
That's right. And let's just finish up with this.
Okay.
We love talking about communication, right? We can give the legal advice, but what does it matter if employees, right, don't know? I bet it's been a long time since our clients' leadership or HR departments have communicated with employees about what the current status is regarding their COVID policy, when you should come to work.
Well, yeah, because they didn't know.
Well, now they do.
Right.
Now they do. So let's finish up with a suggestion, right? That, remember, back in the day, there were emails going out sometimes multiple times a week as things
Yes.
changed, but usually weekly or every other week, saying, here's where we stand as an organization. Here's what we expect of you. Why not do that again now? Because your employees are just as confused as leadership is about what the latest
Right.
standards
I
are.
think that's a great idea. Well, this has been a really helpful conversation, I think. Hopefully our listeners got some of those old clothes out of their closet or are going to, right? The old jeans, the old boots. Just because it fits doesn't mean it should stay, right? And that it's provided a bit of peace of mind for our listeners. All right, you ready to get back to work?
I am Sarah. See you
All
soon.
right, see you next time.